Hey everybody, John Skiba here. It's Thursday night. We're live on the Consumer Warrior YouTube channel. Let's get started. Welcome once again. It's Thursday night here. John Skiba from the Consumer Warrior YouTube channel. I'm also an attorney in the state of Arizona with the law firm of Jackson White here in Mesa, Arizona. I am a consumer protection and a bankruptcy attorney in the state. And I help people who are dealing with serious debt problems, not people who are just dabbling in debt, but people who got some serious debt issues that they're dealing with. And that's what we talk about here on the channel. The whole idea of my YouTube channel was to provide information and tips and strategies for people that are dealing with serious debt problems and how they can deal with them overall and to try to move forward and get those things in the rearview mirror. It's important to note this should not be considered legal advice. This is just some guy talking on YouTube. If you need actual legal advice and you're in the state of Arizona, my information is right here below. I do free consultations related to debt collection lawsuits, bankruptcies, those types of things. If you're in another state, I do have some other resources. Like last week, we talked about Solo Suit. They are a sponsor of this live stream each week. Their information is in the chat section and it will be below here where you can check them out and see exactly what different types of products they offer. I also have the Consumer Warrior University. All of that information is in the chat section over there on YouTube and on Facebook, so you can click on that and learn more about that. So the way that we do this each week is if you have a question, go ahead and put it in the chat section in YouTube or on Facebook. I'll put it up on the screen and we'll go over it and give you some different direction and things like that, or how you might be able to resolve it. Something I talked about last week that I want to do is I want to start incorporating into this each week a resource of the week or some kind of tip or tool that you can use as you're trying to deal with serious debt issues. Now, the one I want to focus on this week is something from it's Google Scholar. Let me share my screen with you and we can take a look at it as far as what Google Scholar is. So Google Scholar is a tool that Google has, obviously, that helps you to find case law and information that you need to be able to cite to different citations. So the reason why, or what, when you would use this is, let's say that you've been sued by a debt collector and you need to file a motion, or you're responding to a motion for summary judgment, or you're responding to a motion to compel arbitration, or you want to file a motion to compel arbitration. Something we talk about here a lot. I have my tutorials and templates through Consumer Warrior, which are very helpful, but often you need specific information to your state. Now, we've talked about in videos before that ChatGPT is a powerful tool, but it's also something we talked about you got to be really careful of, because there was an attorney back east that was using ChatGPT to get case law for the authority for his briefs, and it was turning out that it was just making it up. ChatGPT was. So one way, if you're using that as a tool that you can clarify if it's an actual case, is by going to Google Scholar. Now let me show you what Google Scholar is. The website on it is just scholar.google.com, and you're going to get this screen here, and you can see there's the two little buttons here. One says if you want to search for articles, and the other one says case law. Now, in understanding, you want to click case law. And what case law is that's really the authority. You have to provide courts with legal authority. You can't just say, hey, judge, I want you to rule it this way because I say so. You have to show what prior courts in your specific state have done with those specific issues. There's precedence. It's called stare decisis. It's where judges in higher courts, their rulings are binding on courts that are lower. That's why it's such a big deal when the U.S. Supreme Court issues a ruling, because it's binding in all those courts that are lower than them. Those judges then no longer have discretion to deviate from what the Supreme Court has told them. And so this is what you want to find, is you want to find information on whatever the topic is. And we can do kind of a quick example here. But so the way that you use it, again, you come to the homepage, you want to click on case law, and then you'll see here, it immediately populates with federal courts and Arizona courts. And that's because this is my, you can see my little picture up here. This is my Google Scholar account. And it's just connected with your regular Google account, or if you have a Gmail account, that kind of thing. But you can click on select courts and you can choose any court in the country. So let's say that I am in Oklahoma. I can click on their Supreme Court. I don't want to get criminal stuff. And then I click done. And then here you can just type in a search. So let's say that let's say that I am like my little search terms here. Let's say I wanted to find any cases dealing with Midland Funding. I can click that in. It didn't match anything. Wow, they must not be there. Let's see. This is let's see if I do Resurgent Capital Services. Let's see if the junk debt buyer. Huh. I wonder why it's not coming up. Boy, this isn't working out good. Let's switch courts. Let's switch to an Arizona court where I know my oh, there we go. I think I had one of the little buttons pressed wrong. So okay, so you can see here I did Resurgent Capital Services, and then it's showing me all these cases where these courts have dealt with Resurgent. And you can, like, if I over here, I can say, okay, I want to see it in Arizona courts. There isn't any. But if I go into the federal courts, there's quite a few with Resurgent. Or if I want to, and you can even break it down, you can see over here by year. If I want to get something, let's see, is there something that's pretty current that I want to look at? And you can put also like legal terms in here. Like, let's say you wanted a motion to compel arbitration. Okay, we're doing this on the fly, and then you're going to see there's all this case law. And then let's say I want to find it in, let's clear all the federal courts, and let's say that I want to do it in California. Click on done, and then you can see how it says Cal here. It's giving me just the California cases, and so it's a good way, and it's free. First of all, that's the one big thing when it comes to law like this, like we use Westlaw in attorneys' offices, and it's crazy expensive. And so this is a free resource where you can get access to it. It's not perfect, but it's a way, one, to be able to check if you have, if the cases are real, if you're doing some kind of AI type thing like Chat GPT, to make sure that you have real law. But it's also something where you can go and it allows you to be able to look at the cases that are out there and maybe see if there's some issues that are similar to what you've been looking at. So that'll be the resource for the week is Google Scholar. Last week I had talked about a new partnership that I have with SoloSuit. SoloSuit is a company. They use software to help people. The things they do here is like reply to debt collection lawsuits. They can help draft a response. They actually have debt settlement services where they're helping you to exchange offers. They have a motion to compel arbitration, which I also have in the Consumer Warrior University. My courses are a little more instructional. These are more software based and can provide you with some really awesome things as well. And then replying to a collection letter, a debt validation letter. I actually have a video coming out on how to do this, but these are awesome resources. You can see 154,000 people have been helped through SoloSuit. 4.8 rating, almost 5 stars on all of their things here. So SoloSuit does a great job. If it's something where you have interest in that, click on the link there in the chat section, and they would be happy to help you and see if they can help get you moving forward. So, okay, with all that being said, let's go ahead and jump into our questions in the comments. We already have a few over there. We got Travis family. Man, thanks for supporting the channel. I appreciate that sincerely. Let's go over to your question right here. It says, got a second notice of discovery demanding my driver's license from an attorney. It's over an $800 hospital bill in the state of Arizona. So when you get discovery request, so from the other side, so they send you, the three main written discovery requests are requests for production of documents, interrogatories, which are like written questions, and then they'll send over a request for admissions. For something like this, where they're wanting like a copy of your driver's license, and they're asking for, that would be in a request for production. Typically in civil suits, they're not entitled to personal information. Like they can't say, hey, give us your social security number. You can raise an objection to it. So if you feel like there's something that you shouldn't have to turn over because it's confidential, it's privileged, you can raise an objection to it. And then if they disagree with that objection, they can take that before the court and ask the court to rule on it, whether you should have to turn that over. That's out of the ordinary. A driver's license, a copy of that. To me, I would object to that. You'll see that they'll do that. If you send them written discovery requests, they object to everything. They turn over nothing and they object to everything, saying it's confidential, it's work product, all this kind of stuff. So that's something you can object to, but don't just ignore it. You actually need to respond to it and say, I'm objecting to this. It's not relevant to the lawsuit and it has my personal information, because a lot of times what I see with collection law firms is they will request written discovery of unrepresented people in effort to try to get information so they can collect on a judgment. Like they'll start asking for your paycheck stubs, tax returns, things like that they're just not entitled to at this stage. Now, if they get a judgment against you, they can do post-judgment discovery and they can get a lot of that stuff. So you got to be careful there. So, all right, let's see here. David was here nice and early, said, Experian has increased my FICO by 15 to 22 points twice this month, only to lower the score below the starting point, saying a late payment was reported. I disputed this because no accounts are late. Any suggestions on this? The dispute's the way to do it. Like I said, there is a law called the Fair Credit Reporting Act, and it deals with, it's kind of the rules, the federal rules over how these credit reporting agencies, which are private companies, how they deal directly with consumers. Now, if you do have a claim under the Fair Credit Reporting Act, one of the prerequisites to that is that you file a dispute through the credit reporting agency stating and see if you can get it resolved that way. So it sounds like you've already done that. It's a 30-day process for them to be able to deal with that, where they're going to have to give you information on what was late. And if not, they're going to have to fix it. So you're taking the correct route there as far as getting that squared away. So, all right. Keeley says, 13 days after submitting my answer to a Midland lawsuit, the status online states mediation referred. What exactly does that mean? And does any information in your university help with or address this? So mediation referred, what that's telling me is that the case has been referred to mediation. So mediation, there's a lot of shuns. There's arbitration and mediation in collection lawsuits. Mediation is the process where the court will submit it to mediation. They'll appoint an independent third-party mediator who will then meet with the parties. Usually, I have been seeing it being done on Zoom in some courts here in Arizona. To me, it's really ineffective to do it via Zoom. But in the old days, in the pre-COVID days, how mediation was done and how a lot of courts still do it is they'll have the parties come to the courthouse. They'll put you in separate rooms. And this mediator will just bounce back and forth, seeing if there's some type of middle ground, some type of settlement. And often it is a good way to get a good settlement done and to get the case just dealt with and over, because the mediator often will go in and kind of play devil's advocate on both sides. They'll go over to the creditor and say, hey, look, we think your case is not that great. And plus, Keeley over here has no money to pay you. So why don't you take this low settlement offer? And then they'll come over to you and say, look, if you go to court and go to trial and you lose, you're going to get the full amount. They're going to get attorney's fees and life's going to be horrible. So why don't you just offer something? And, they'll kind of go back and forth. It's more formal than that. And they're honest the way that they do it. But they their goal is to try to get you to come to some middle ground and see the light as to why you should do that. So that's what mediation is. The Consumer Warrior University, my tutorials and that, I don't have anything on mediation. I mean, there is one on settlement, and it'll give you some strategies on how to approach mediation. You could go check that out. The Consumer Warrior University, right now it's $47 a month, and you get unlimited access to all, I believe there's 14 tutorials. As well as all my templates, forms, and that, and you can just cancel it after a month. So you may want to go there and check it out, see if it's something that may be helpful. But there is a section on settlement and the strategies that I take when trying to settle a case, is how that works. So, all right, let's see here. MGK says, hey there, love all the content you provide. Thank you. Question: after several delivery attempts, someone finally slid a summons under my apartment door. Was it work? And I live alone. Any advice? Thanks. Service of process is, I'll tell you my approach to it. Trying to avoid service or dodge service when you actually get the complaint, to me, it's better just to face it head on. Just get the complaint and let's deal with it. There's things you can do, file the answer, motions to compel private arbitration, settlement, all these kind of things, bankruptcy, whatever it is. It's a great way for you just to deal with it, because the concern I have, do I think that this service of sliding under the door when nobody's home is good? In Arizona, that would not be good service. They've got to serve you at home or somebody who lives with you at home. They can't just slide under the door and say, unless the court has told them they can do it. Sometimes there's what's called an alternative service order, where the judge has given them permission to mail you a copy and then post a copy to your door. So that's what I'm saying. There's all these kind of variables. If you've got the summons and complaint, my recommendation is let's just get an answer filed and get it dealt with, rather than to just let it, kind of linger like that. Because the answer is something fairly easy to put together. That's another thing with the solo suit thing that they're doing here. They have this reply to a debt lawsuit. That's what my link there down below will get you access to that. But that's something where absolutely you can get that dealt with and get the answer filed, avoid default. I see too many people that try to kind of avoid it, then they end up with the default judgment. And once that default judgment's entered, it makes life much more difficult. So that would be my recommendation. So Keely, thank you. Sincerely, I appreciate that. Appreciate you supporting the channel. All right, let's see here. See what Sandra has to say. I ran up several credit cards after 10 years of on-time payments. They lowered my limits simply for minimum payments. I can't repay the 6 accounts. Do I wait to see what they do or file Chapter 7? I can tell you with Chapter 7, you don't have to be behind on your credit cards to file. A lot of people are surprised at that. They'll say, I'm current on my credit cards. Do I need to let them fall behind a few months and then file the bankruptcy? No, you don't. You can file at any time. And frankly, your credit score is going to recover a little bit better than it would otherwise. So, if it's something where you can't make the minimum payments or you don't think you're going to be able to get these paid off in the next, say, 3 years, it's something where you might want to start looking at a Chapter 7. Again, if you're in Arizona, I do free consults where we can dive in. There's a lot of different things you have to look at. Do you qualify for a Chapter 7? Or do you have non-exempt assets at your risk of losing? That we really like to kind of dig, deep in there to be able to see if it's a good option. But if it's something, if you can't repay it, if you just stop paying altogether, eventually, you're going to be having to come back here because you're getting sued by a debt collector, and we're going to be dealing with filing answers and all that kind of stuff. So I often say, if you get sued by a creditor, well, when people call into my office with like a junk debt buyer lawsuit, I always give 3 options: fight it, settle it, or file bankruptcy on it. Those are your 3 options. And if it's something where you wouldn't even be thinking about bankruptcy, but for this lawsuit, then I say, hey, let's go ahead and let's deal with this and get it out of the way. If it's something where we're going to win 1 lawsuit and then 3 more are going to replace it 2 months down the road, I'm like, maybe we should look at a Chapter 7 filing and get that dealt with. So that's kind of the approach I take as far as to getting it squared away. So Al, thank you. Still enjoy the weekly Q&A. There's some regulars like Al here who are here almost every single week, and it's impressive. I appreciate that. And you've been here right from the very beginning. So I appreciate you tuning in each and every week. All right, let's see here. Eric says, is it possible to request that mediation be in person as opposed to in Zoom in Arizona? Yes, you can ask the court. If you get a notice, because what they do is they'll send out a notice of mediation, and it'll usually say it's via Zoom. You can file a motion saying, hey, judge, I want to be in person. I can tell you it's much more likely to settle if it's in person, just because I always say this: all the parties should be equally inconvenienced in mediation. Attorneys always joke that the hallmark of a good settlement is that nobody's happy. The creditors thinking they took way too less and the consumers thinking they paid way too much. But you can absolutely request it. It's not always a guarantee that the court's going to allow it, but I think they will. Arizona courts are fully open. I mean, it's not like they have to do it. They just do that for convenience. One thing I would do if you're going to mediation, I would require this. So the court will send out an order that says that the attorneys and their clients need to be there. What you will see all the time is that you'll show up, or if you have an attorney, you and your attorney will show up, and the debt collector will just show up and say, I have authority to settle and negotiate this. I always try to get confirmation ahead of time that their client will be there. If you're getting sued by LVNV Funding, I want somebody from LVNV Funding plus their attorney there. And it goes back to this thing that we should all be equally inconvenienced. If they're the ones that sued you, they brought this lawsuit. They knew this was a possibility. And because if we're all equally inconvenienced, then there's more motivation to get the thing settled. So that's something I would fight for. And you shouldn't have to fight that hard, because almost without exception, at least in Arizona, if you're going to mediation, they require the attorneys and their clients actually show up. Don't let just the attorney go there, because the attorneys, what do they care? That they'll try to get it settled, yeah, but they don't have the same viewpoint or motivation that the actual client will, and they're trying to get it done. So, all right, let's see right here. Vicky says, "Hi, John. If I lose my debt collection arbitration with portfolio, can I discharge their attorney's fees in a bankruptcy Chapter 7, assuming they get an award?" The answer is yes. I mean, there's nothing, even if if you go to court and you lose and they get a judgment against you, yeah, you can absolutely discharge that in bankruptcy. Now, the exceptions to discharge in bankruptcy are, debts incurred through fraud. If you incurred a debt and it was fraudulent, then no, the creditor can come in and raise an objection to that. But other than that, I mean, the only types of debts that typically don't go away are most taxes, student loans, child support, spousal maintenance, that kind of stuff. So even if they got an arbitration award, particularly for attorney's fees, there typically is no issue at all there as far as them being discharged in a bankruptcy. So, all right, let's see here. Thank you very much for supporting the channel. Since the debt buyer, Revco, filed a motion to set aside ordered mediation, I replied to the court with a letter to reject the motion to set aside the order of mediation. Any advice would be highly appreciated. So I guess you can clarify to me. So that they were saying they didn't want to attend the mediation hearing, or there was a mediation held, a settlement reached, and then they were trying to set aside that settlement agreement. Maybe you can clarify that for me, because usually, I mean, the court's going to require, at least in Arizona, if they say, "Hey, you're going to mediation," you're going to mediation. There's no, "Hey, I don't want to do that." It's their world. We just live in it, and so we do what they tell us to do, even if we don't think it's going to be fruitful. So if you want to, I can tell you this: if it's something where you went to mediation and there was an agreement entered, that's a binding contract. That's a binding contract between the parties. And if they're trying to back out of it at this point, then you could actually file a motion to enforce the settlement agreement with the court. So if you want to double check, if there's more information, I'm happy to follow up on that one. But let me know where you're at with that one as far as exactly what happened there. So, all right. Randman Sports Card says, I have 4 charged off credit cards, 2 from Citi, 2 for Capital One. Both Citi cards have sued me. I know it's a matter of time before Capital One sues me. Can I consolidate all 4 cards into one debt? Well, you're not going to be able to consolidate the cases. The cases will stand on their own because they're probably, maybe they're all the same attorney. I don't know. But no, typically they're going to keep all 4 separate. They're not going to consolidate them into one. And truthfully, I would want them kept separate, particularly if it's 2 separate, if there's Capital One and Citi, those may be good ones to push into arbitration. But typically, no, they're not going to consolidate all that together. So, all right. This C here says, my LLC has some debt that is strictly business and some debt that is personally guaranteed. Is it okay to pay off all personally guaranteed debt 90 plus days before the LLC has bankruptcy liquidation? So I can tell you this, it's rare where LLCs or corporations file Chapter 7, first of all, right out of the bat. So, and the reason why, one time a law professor explained it to me this way. He said, because Chapter 7 is typically for individuals. LLCs and companies can file it, but the whole point of an individual, if I'm filing Chapter 7, my whole point in doing it is to get a bankruptcy discharge, which is that order from the judge saying I don't owe these debts anymore. LLCs are not entitled to a discharge. So there's really no reason, the way that this law professor described it is he says, when a company dies, you can have a great big fancy funeral called a Chapter 7 bankruptcy, or you can just dig a hole and put the business in it and be done with it. The rare reason that you file a bankruptcy for most situations for like an LLC, like I had one once where I remember the client had a giant warehouse of lawn chairs, of all things. It was a business that sold like patio furniture, and they had this giant warehouse full of lawn chairs, and they had closed down. They weren't doing business, and the guy's like, I don't even know what to do with these. And so we filed the Chapter 7. The bankruptcy trustee came in, appointed an auctioneer to come in and auction these chairs off, paid out the creditors, and then just closed the case out. So But to your question, as far as if there's debts that are personally guaranteed, the issue here is our preferences, as far as what you're talking about. If it's something where you're paying off something in the 90 days prior to filing bankruptcy, or they're just going to go back and reverse it. If you're paying debts and it's been more than 90 days, you're not going to have any issues because you're outside the look back period, unless you are paying them to an insider. Let's say that there were debts that were insiders to the business, that were shareholders or members of the LLC or something like that. So either way, I can tell you this. If the debts are personally guaranteed, if the company were to file bankruptcy, you're still on the hook anyway. So whether you're paying them now or later, probably doesn't matter. So, all right, let's see here. Oh, and to go back to your question. So you're doing mediation. If you want to do mediation, and like I said, mediation is a great way to get cases resolved. I would object to it. If they filed a motion to set aside the order of mediation, file an objection. They got to have a reason. The court's ordered you to attend. And so if they haven't really articulated a reason, or you can object to saying, no, I want to do the mediation. And courts love mediation. Courts have so many cases. The one thing they want to happen is to get this thing settled. And so they'll require the parties to at least try to attend. So, all right, Alex, another one of the regulars here each and every week. Shout out to Yuma, as always. Do courts usually rule from the bench on motions for summary judgments, or do they hear oral argument? Differences between the superior and the justice courts here in Arizona. So, for people in Arizona, superior court deals with cases over $10,000, and justice court deals with the cases under $10,000. Now, motions for summary judgment, this is when basically the creditor files a motion for summary judgment and they say, hey, look, we basically what they're saying is, Judge, look, we don't need a trial. Just look at our stuff. Look at all our documents and tell us if we win. If you file a response to that, you need to object to it and say, no, we do need a trial. There's all these different issues, factual issues that are in dispute, and that's why we need it. The court then has two options. Once they file their motion, you file a response, and then they get the last bite at the apple. They can file a reply brief. Once it's been fully briefed, they then can take the court could take it under advisement and just issue a written ruling, which I can tell you happens in probably over 95% of cases. Or if the judge has questions about it, they can set oral argument. Where with attorneys, this is when the attorneys come in and we argue our sides of the case. The judge asks questions, and then the judge will issue a ruling then. So I can tell you that, like I said, most cases you're just going to get a written ruling. The ones where I tend to get oral argument tend to be ones where there are questions that are kind of close about the statute of limitations. If it's something particularly like an installment contract where we have like a student loan or an old car loan where, maybe some of the monthly installments are outside the statute of limitations and others aren't. Sometimes the judge will bring the parties in to answer questions about, things like that. So that's typically what I see. Usually you can expect them just to issue what's called a minute entry or a ruling stating, justice court, you're going to get a check the box. It's either granted or denied. Superior court, you're going to get an actual findings of fact and application of the law so that you know exactly why they granted it or why they denied it. So, all right. Daniel says, I own several credit cards, but I inflated my income in the application. Will this prevent me from getting my debt discharged through Chapter 7? So good question. So you're saying in the application that the income that you listed was not accurate. And so the issue, I guess, concern is it fraudulent? Was the debt incurred through fraud? I guess that the question, to me, there's two different questions. Was the debt incurred through fraud, or was that fraudulent, or was that an actual intentional misrepresentation? Those are all factual questions that could be decided by the court. I guess the secondary question, have I ever seen that issue come up in the bankruptcy court in 20 years of filing bankruptcies? No, I haven't. That's a pretty intense factual type determination, as almost all fraud cases are, because it goes to your intent. It has to go back to looking what the income was. So while I'm not condoning that, obviously you need to put accurate information on those applications. Do I see creditors or credit card companies come in and object on that basis? I have never seen it. That's not to say that it doesn't happen, but I have never seen it happen. And so that's definitely one to talk to an attorney about. Let them look at the very, kind of dig into the facts of that to see if that's going to be an issue. If you anticipate it's going to be an issue, then you can look at other options. If you end up filing bankruptcy, you know that may be an issue, and you may end up paying that specific card back. Or maybe something can be negotiated, but definitely talk to an attorney about that one just to see if there's going to be any issues. So, all right, let's be Randman here, can finish this off. What if I don't have a job or any income right now? What can they take in a garnishment? I don't own a house. So good question. Once a judgment is entered, the whole point of a credit card company wanting to sue you and get a judgment is because a judgment gives them a lot of power that they don't have otherwise. Otherwise, they're typically just an unsecured creditor. And this is really kind of the big reason, and I've told this to courts before. I'll say, hey, judge, the reason why it's so important that we jump through all these evidentiary hoops, that they have good evidence, that they have good witnesses, that we know for sure the amounts owed, that we're not just making assumptions on this, is because that these safeguards are in place because the end result is a judgment, which all of a sudden now they have things that can really impact people's lives. Wage garnishment, the low-hanging fruit for a creditor collection person is wage garnishment, bank levy, where they come in and sweep money out of your account, and to record it. And then in most jurisdictions, it can act as a lien if they record it with like the county recorder. It'll act as a lien against any real estate or real property that you have in that particular county. So if you don't have a job, there's nothing to garnish as far as income. They could look at bank accounts. Bank accounts are a little bit tricky for collectors because, if they know that you bank at Wells Fargo or Bank of America, they can get a writ of garnishment. They can serve it on the bank, but it's really, they're doing it. It's a fishing expedition. The bank can't tell them how much money is sitting in the account. At the time they serve that writ, they serve the writ, and whatever day it hits, the bank will look and say, okay, here's how much money is in here. Then they have to apply an exemption. Like in Arizona now, that Prop 209 passed, exemption, your bank account is $5,000. If they try to levy your accounts and you're in Arizona, and the old exemption was like $300. So if they try to take anything and you have $5,000 or less, you need to object to that. But and so if there's nothing in there over 5,000, then the bank will just say it's all exempt. It's in here. But that's generally where you see it. Otherwise, they'll just record it. Often collectors will even record the judgments, even if you don't own real estate, just in the event that you do. You buy a house, it can then act as a lien against that for when you try to refinance or when you try to sell it. That can become an issue. I don't see a whole lot of them going after personal property unless the judgments are very large. And then they can get a writ of general attachment and they can try to go after non-exempt assets, boats, motorcycles, additional vehicles. That's a lot more tricky as well. And so you typically don't see it just in like credit card litigation. You see it in bigger litigation, that kind of thing. So, all right. I think that will probably do it for tonight. Hey, I appreciate everybody that came tonight. We have a pretty big crowd. Again, I recommend you head on over to Solo Suit. Check this out below if you're looking for help with verification letters, responding to a lawsuit, motions to compel, even debt settlement services. Check out the link to Solo Suit. That they do a great service and helps support the channel. And then also check out my Consumer Warrior University, where again, I have the subscription where you can get access to everything for a month. And if it's great. If not, you can just cancel after that. We also have the online Consumer Warrior community that can really help you out. So, all right. I think that will be it. But if there is anything else, put them in the comments. I try to get to them each and every week. And with that, we'll catch you next.